The children arrived on a Thursday. 40 of them. Irish Catholic orphans from the New York Foundling Hospital, transported by train across 2,000 miles of continent to a copper mining town on the Arizona-Mexico border. Each child had been matched, by correspondence, with a Mexican Catholic family in Clifton. Families the Sisters of Charity had vetted through the local parish. Families who had agreed to take a child, raise them in the faith, give them a home. The placement was legal. The sisters had followed their standard protocol. The receiving families had been approved by the parish priest. The paperwork was in order. By Sunday, the children were gone. Not all of them, and not quietly. The Anglo Protestant families of Clifton had spent the intervening 72 hours organizing. They had sent telegrams. They had assembled a mob. Armed men had gone, house by house, to the Mexican families who had taken the children in and removed the children by force. The Sisters of Charity who had accompanied the placement were threatened. At least one was held at gunpoint. By the time the dust settled, 40 Irish Catholic orphans had been redistributed. Without legal process, without court order, without any paperwork at all, to the Anglo families of Clifton who had decided, collectively, that Mexican homes were not appropriate homes for white children. The New York Foundling Hospital sued for the return of the children. They lost. And the legal reasoning the court used to explain why they lost is the part of this story that the archive preserved most carefully. Here is what the New York Foundling Hospital actually was, and what its Placing Out program was designed to do. The New York Foundling Hospital was established in 1869 by the Sisters of Charity, a Catholic religious order, in direct response to the Protestant orientation of the Children's Aid Society and its orphan train program. Charles Loring Brace's Placing Out system, which had been running since 1853, placed children predominantly with Protestant rural families. The Catholic Church's objection was explicit and documented. Catholic children were being removed from the faith of their birth and placed in households that would raise them Protestant. The Foundling Hospital's train program was the institutional answer, a parallel system that placed Catholic children with Catholic families, vetted through parish networks, in communities where the Church had an established presence. The Clifton placement was not an improvised operation. It followed a protocol the Foundling Hospital had used across multiple states. The receiving families in Clifton had been identified through the local parish of Our Lady of Guadalupe. The priest had vouched for them. The sisters had corresponded with the families before departure. The children, 40 in total, ranging in age from approximately 2 to 6 years, had been matched to specific households before the train left New York. What the sisters had not fully accounted for was the racial geography of Clifton in 1904. Clifton was a copper mining town in Graham County, Arizona Territory, not yet a state operating under territorial law, with a social order structured around the copper industry and the ethnic hierarchies that industry had imported. The Anglo-Protestant population controlled the mines, the management positions, and the civic institutions. The Mexican Catholic population provided the labor. The two communities lived in proximity and in tension, separated by the informal but rigorously enforced boundaries of a company town in the extractive West. The Sisters of Charity arrived with 40 Irish orphans and placed them in Mexican homes. And here is where the bridge of relevance matters. Because the experience of a legal placement being overturned by community consensus, enforced by armed men, and subsequently validated by a court that found the community's consensus more persuasive than the legal paperwork, is not a condition unique to Arizona in 1904. It is the operational description of how extra-legal racial enforcement has repeatedly been laundered through legal process. The illegal act comes first. The legal rationalization follows, and the record that results describes the outcome as if it had been orderly from the beginning. The mob acted on Thursday night and Friday. The court acted months later. But the court's reasoning began from the fact of the mob, from the children already being in Anglo homes, and worked backward to justify it. Maybe the Anglo families of Clifton genuinely believed they were acting in the children's best interests, that Mexican homes, in their assessment, were unsuitable environments for white children, and that their intervention was protective rather than predatory. If this were the whole picture, misguided but sincere community members taking extra legal action from genuine concern, the story would be a painful chapter in the history of American racial paternalism, but not a story about the law's complicity in that paternalism. But the record refuses to stay that charitable. The telegrams the Anglo residents of Clifton sent in the 72 hours between the children's arrival and the forced removals are in the archive. They were sent to the territorial governor, to the sheriff, to newspaper editors in Phoenix and Tucson. Their language is specific. The objection was not that the children were being placed in unsuitable homes. The objection was that white children were being placed in Mexican homes. The racial category is explicit in the correspondence. It is not inferred by later historians reading between the lines. Archival patterns suggest the sheriff of Graham County was aware of the planned removals before they occurred and took no action to prevent them. The territorial governor, who received telegrams describing what was happening, also took no action. The extra legal removal of 40 children from legal placements proceeded without interference from any law enforcement authority in Arizona territory. The children were in Anglo homes before any court had said they should be. The New York Foundling Hospital filed for writs of habeas corpus in the Arizona territorial courts, the legal mechanism for demanding the return of persons held without lawful authority. The argument was straightforward. The children had been legally placed with specific families by a legally constituted institution operating under valid agreements. Armed men had removed them without court order. The children should be returned to their legal placements. The territorial court denied the writs. The reasoning the court used is where the record becomes a document about something larger than 40 children in a copper mining town. The court did not rule that the removals had been legal. It did not find that the Anglo families who had taken the children by force had any lawful claim to them. What it found, and what the Arizona Supreme Court affirmed on appeal, was that the children were now better off in their current placements, and that returning them to the Mexican families from whom they had been taken would be contrary to the children's welfare. The court had been presented with an illegal act. It responded by evaluating the outcome of that illegal act and finding the outcome acceptable. C2, the specific language the Arizona Supreme Court used in its 1904 ruling, is in the legal record. Historians who have examined it note that the court's assessment of the relative fitness of Anglo and Mexican homes was not based on any investigation of the specific households involved. It was based on the court's general assessment of the two communities, an assessment that tracked, with precision, the racial hierarchy that the Clifton mob had enforced at gunpoint. The court did not investigate the Anglo families who had taken the children. It did not interview the Mexican families from whom the children had been removed. It accepted the social consensus of Clifton's Anglo community as evidence of the children's best interests. The mob set the terms. The court accepted them. The case reached the United States Supreme Court in 1906. The Foundling Hospital's appeal argued that the territorial court had violated the due process rights of the legal guardians and the contractual rights of the placing institution. The Supreme Court declined to reach the merits of that argument. It ruled on jurisdictional grounds, finding that the children, now residing with Anglo families in Arizona, were not being unlawfully detained in any sense the federal courts could address. The children were not returned. If this investigation is landing differently than you expected, subscribe. The next one follows a different court record. One where the legal reasoning used to validate an extra-legal act left a paper trail that the official history has never fully assembled in one place. Now, consider what happened to the Mexican families from whom the children had been taken. The Foundling Hospital's litigation focused, necessarily, on recovering the children. The legal record it generated documents the institution's claims, the court's reasoning, the appeals process. What the legal record does not document, what no proceeding generated a formal account of, is what happened to the families who had prepared homes, who had corresponded with the sisters for months, who had gone to the parish to be vetted, who had received a child on Thursday and had that child removed by armed men before the week was out. The record is silent on whether any of those families received any communication from the Foundling Hospital after the removals. Silent on whether any legal action was taken on their behalf. Silent on whether the parish priest who had vouched for them faced any consequences for the role his endorsement had played in bringing them into a situation the Anglo community then used to humiliate them publicly. The families appear in the record as receiving households in the placement documentation. They do not appear again. The institution kept records of the children. Nobody kept records of what the town did to the families. The Supreme Court's 1906 jurisdictional ruling did not resolve the legal question it declined to answer. What the court established, by declining to reach the merits, was a precedent of absence, a case in which the federal judiciary had an opportunity to rule on whether an extra-legal racial mob action, subsequently validated by a territorial court, constituted a violation of constitutional rights, and chose instead to find a procedural exit. The question of whether 40 children could be permanently redistributed along racial lines by armed community consensus, without court order and without due process, was not answered in 1906. It was simply not asked. The Clifton case entered the legal history as a footnote in the development of child welfare law, cited occasionally in scholarship on the history of placing out programs, on the legal status of foundling hospitals, on the intersection of racial ideology and child custody doctrine in the territorial West. It was recovered as a substantial historical episode primarily through the work of Linda Gordon, whose 1999 book, The Great Arizona Orphan Abduction, reconstructed the case from court records, newspaper archives, and the Foundling Hospital's institutional files. Gordon's account established what the court record alone could not: the full sequence of who knew what, when, and what they chose to do with that knowledge. The 40 children grew up in Clifton. Some stayed in Arizona. Some dispersed across the West. The Foundling Hospital's records show no further contact with the placed children after the litigation concluded. The Mexican families who had been approved as receiving households appear in no subsequent Foundling Hospital correspondence. The institution filed its last appeal, lost, and moved on. The town of Clifton kept the children. The court said that was close enough to legal. The archive disagrees.